In this lecture, let us discuss union territories. If you recall, we discussed part 1 of the Constitution of India, Union and its territory. Then we discussed Articles 1 to 4. We discussed Schedule 1 of the Constitution of India. Then I told you that there are 28 states and 8 union territories specified in the first schedule of the Constitution of India. But in part 1 of the Constitution of India, our primary focus was on reorganization. Our primary focus was how the states can be admitted into the Union of India, how the states can be established. Our primary intention was how can the reorganization of the country into states and union territories take place. But why are there 8 union territories in India that we will discuss now? What is the structure of governance in all these union territories that we will discuss now? And at the end, we will ask a very important question. Is it time that we should abolish all these union territories? Or should we ask, are union territories outcasts of democracy in India? Is it time that we should abolish all these union territories and make them states in India? That is a very important question that can be asked in your mains examination. But first up, let's look at the idea. We have 8 union territories in India. But for what reason? Very broadly, I will tell you the reasons. And towards the end of this lecture, we are going to get into the specifics. Why exactly do we have 8 union territories in India? Right now, I'm going to tell you very broadly why are there 8 union territories in India. For political reasons, for administrative reasons, Delhi and Chandigarh, they are union territories. Why Delhi? Because Delhi is the capital of India. And if you look at the capitals of almost all the countries of the world, they are directly controlled by the center. For example, Washington DC in the United States, Canberra in Australia. Despite the fact that Australia and the United States, they are a federal constitution, but their capital cities are directly controlled by the center. In a similar fashion, Delhi is the capital of the Union of India, of the country. That is why Delhi is a union territory. But the structure of governance in Delhi is slightly different. Because in Delhi, we have a legislative assembly, we have a chief minister as well. But that is something I'm going to tell you slightly later. Chandigarh, for example, Punjab was to be divided. Punjab was to be reorganized. Punjab was to be divided into Punjab and Haryana, and the hilly parts of the state should be merged into Himachal Pradesh, for example. That was the reorganization done. But the question arose over Chandigarh. Punjab laid its claim on Chandigarh. Haryana also laid its claim on Chandigarh. Chandigarh, this beautiful city, smokeless city, designed by Lee Corbusier. The question was whether Chandigarh may be part of Punjab or Chandigarh may be part of Haryana. Ultimately, the central government decided that for 10 years, we should have Chandigarh as a union territory. And then after 10 years, we will decide whether Chandigarh will be part of Punjab or Chandigarh will be part of Haryana. But those 10 years are still not over. That means since there is no clarity, no consensus on Chandigarh, Chandigarh remains a union territory. For political reasons, Chandigarh is a union territory. For administrative reasons, NCT, the National Capital Territory of Delhi, is a union territory because it is the capital of India. Similarly, for cultural reasons, because of their cultural distinctiveness, Puducherry is a union territory. Dadra Nagar Haveli and Daman and Diu also is a union territory. Initially, Dadra Nagar Haveli was one union territory, Daman and Diu was another union territory. But effective January 26, 2020, both these union territories were merged. So now we have a common union territory. Dadra Nagar Haveli and Daman and Diu is one union territory. But because of its cultural distinctiveness, because its culture did not fit with the culture of the neighboring state, that is why it was created as a union territory. And Puducherry, you would recall, it was an acquired territory till 1962. This French settlement of Puducherry, it was an acquired territory of India, and in 1963, it was given the status of a union territory, primarily because of its cultural distinctiveness. Then we have for strategic importance, because of where they are situated. Their location is of strategic importance to us. Lakshadweep and Andaman and Nicobar Islands. That is why they are a union territory. Jammu and Kashmir was a state. In fact, the state had a special status under Articles 370 and 35 capital A of the Constitution. But on August 5 and 6, the relationship of the state of Jammu and Kashmir with the Union of India was altered. The year was 2019. Jammu and Kashmir's special status was taken away and it was downgraded to that of a union territory. It was also bifurcated into 2 union territories. Union territory of Jammu and Kashmir, Union territory of Ladakh. Jammu and Kashmir will have a legislative assembly, just like Puducherry has a legislative assembly, just like Delhi has a legislative assembly, just like Delhi has a chief minister, Puducherry has a chief minister. Jammu and Kashmir will also have a chief minister, despite the fact that it is a union territory. But union territory of Ladakh will not have a legislative assembly. But why was Jammu and Kashmir made into a union territory? Why was Ladakh made into a union territory? The argument of the government was, because I told you in the first class when we discussed union and its territory, that reorganization of the country is basically a political decision. The government of the day thought that look at Ladakh, there was a long pending demand from the people of Ladakh that we should be separated from Jammu and Kashmir, give us a status of a union territory. So the government said, we are accepting and realizing the sentiments of the people of Ladakh. That is why Ladakh is made into a union territory. But what was the logic and rationale for Jammu and Kashmir? The government said there is cross-border terrorism in Jammu and Kashmir, there is infiltration into Jammu and Kashmir, there is a law and order problem in Jammu and Kashmir. So till the time there is some semblance of peace, normalcy, security in union territory of Jammu and Kashmir, it will remain a union territory. Once there is some semblance of normalcy, security, law and order is restored, then Jammu and Kashmir will be given the status of a state again. But till that time, it will remain a union territory. But what sort of union territory? Just like Puducherry, because Puducherry has a legislative assembly. Puducherry has a chief minister and the council of ministers. This reminds me of another very important point. If you look at India is a federal constitution. And what do we mean by federalism? There are 2 important ingredients of a federal constitution, or 2 important characteristics of a federal constitution. One is dual government, the other is distribution of powers. But if you look at these union territories, they are directly controlled by the center, which means there is no dual government, which means there is no distribution of powers as well. If I take into account 5 union territories, Ladakh, Dadra Nagar Haveli and Daman and Diu, Lakshadweep, Andaman and Nicobar Islands, Chandigarh, they are directly controlled by the center. There is no legislative assembly. There is no chief minister. That means they are directly controlled and administered by the center. That means there is no dual government. There is no distribution of powers. That means these union territories, they do not share federal relationship with the Union of India. The federal relationship is shared by 28 states, where they have a dual government, where there is distribution of powers. But that is not applicable for a union territory. Despite the fact that Delhi has a legislative assembly, Puducherry has a legislative assembly, even then there is a control of the center over these union territories, which we are going to discuss very soon. That means despite the fact that Delhi and Puducherry have a legislative assembly, have a popular government in place, Jammu and Kashmir will have a legislative assembly, there will be a popular government in Jammu and Kashmir. Despite that, they are still under the control of the center. That means they do not share federal relationship with the Union of India. That means these union territories are directly controlled, administered, governed by the central government. That means if you look at India, we have distinct constitutional entities. We have a union, we have states, we have union territories. So these union territories, they are distinct constitutional entities, directly controlled, governed and administered by the center. But despite that, there is no uniformity in the administrative structure. Delhi has a legislative assembly and the chief minister. Puducherry has a legislative assembly and the chief minister. But 5 other union territories, they do not have these popular institutions. That means ultimately, if you look at union territories, there is no uniformity in their administrative structure. And you will understand this better when we will look at the relationship of these union territories with the Union of India. First, let's look at the administrative relationship. Let's look at the administrative structure of these union territories. Union territories, as I told you, they are directly controlled, administered, and governed by the center. Now, who is the executive head of the center? The President of India. If the union territories are directly controlled by the center, that means the President is the administrative head, executive head of all these union territories as well. If you look at Maharashtra, Gujarat, Karnataka, Tamil Nadu, 28 states that we have, who is the executive head of these states? Governor. Governor is the executive head of a state. But if union territories are directly controlled by the center, who is the executive head of the center? President. That means union territories, their executive head also is the President of India. But how does the President of India administer these union territories? How does the President of India govern and manage these union territories? Constitution says President manages, administers these union territories through his officers. And these officers can be suitably named. What do we mean by suitably named? That means if Delhi is a union territory, its executive head is the President of India. President administers this union territory through his officer, and this officer is named Lieutenant Governor. Puducherry is a union territory. Puducherry's union territory's head is the President of India. President administers this union territory through his officer, who is named Lieutenant Governor. But for Chandigarh, it is the administrator. There used to be a post of Chief Commissioner also, who would administer these union territories. That means no matter what your designation is, President will administer these union territories by giving a designation to that individual who is administering these union territories on behalf of the President of India. And what these designations can be: Chief Commissioner, Administrator, Lieutenant Governor. That is why we say these union territories are directly controlled by the center. President is the executive head of all these union territories. President administers, governs these union territories through his officers, who are suitably named, and the officer can be a Lieutenant Governor, the officer can be an Administrator, the officer can be a Chief Commissioner. That means there is no dual government in the place. That means union territories are directly controlled by the center. And these Lieutenant Governors, they also have a set of advisors who are advising the Lieutenant Governor. But who are these advisors? Which basically means 6 union territories right now, where there is no legislative assembly, there is no Chief Minister, there is no Council of Ministers. How is Lieutenant Governor going to administer these union territories on behalf of the President of India? He would require people to assist him, but because people cannot vote and elect their representatives, that is why there are advisors who advise the Lieutenant Governor. Someone would advise on finance, someone would advise on law and order, someone would advise on education, someone would advise on revenue. That means we will have a set of advisors advising the Lieutenant Governor, because this Lieutenant Governor is acting on behalf of the President of India and administering these union territories. Clear? That's the administrative structure of a union territory. If you look at the legislative structure, normally the job of the Legislative Assembly is to make laws for a state. The job of the Parliament is to make law for the entire country, for the entire Union of India. But union territories are directly under the control of the center, which is the central legislative agency of India, which is the Parliament of India. That means the Parliament becomes the legislature for all these union territories. That means if for 6 union territories the laws are to be made, for Jammu and Kashmir, Ladakh, Daman and Diu and the Dadra and Nagar Haveli, Chandigarh, Lakshadweep, Andaman and Nicobar Islands, who will make laws for all these union territories? Parliament of India, because these union territories are directly under the control of the center. The central Parliament is the Parliament, Rajya Sabha, Lok Sabha. Parliament of India will make laws for all these union territories as well. As simple as that. But what about Delhi? And what about Puducherry? These are union territories. But these union territories, they have a legislative assembly as well. That means people come out in large numbers and vote for their elected representatives. These elected representatives, they become part of the legislative assembly. That means in Delhi, legislative assembly will make laws for Delhi, except law and order, except land, except police. That means if you look at Delhi, till 1956, Delhi was a state. Delhi had a legislative assembly, Delhi had a chief minister. But this Delhi was converted into a union territory in 1956. And from 1956 till 1992, Delhi continued to exist as a union territory without a legislative assembly, without a chief minister. And then 69th amendment was made to the constitution, 69th constitutional amendment act in the year 1991. 1992, Article 239, capital A was added to the constitution, and Delhi was rechristened as NCT, National Capital Territory. The name was changed. And NCT was given a legislative assembly, NCT was given a popular government. That means they will have a chief minister and council of ministers as well. That means Delhi was given some sort of a democratic structure, where people can vote, people can elect their representatives, they will be part of legislative assembly, there will be a chief minister, there will be council of ministers as well. When we discussed states, and when we discussed the legislature, the parliament, I told you that the strength of the council of ministers and the chief minister, and the strength of the council of ministers and the prime minister, it should not be more than 15% of the strength of Lok Sabha, should not be more than 15% of the strength of the legislative assembly. This percentage for Delhi is 10%. That means in Delhi, there are 70 MLAs to the Legislative Assembly of Delhi. Chief Minister and Council of Ministers, this number should not be more than 7, because 10% of the strength of the Legislative Assembly should be the strength of Chief Minister and the Council of Ministers. That means in 1992, some element of democracy was provided to Delhi. Delhi is a union territory, but it will have a Legislative Assembly as well. This Legislative Assembly has the power to make laws on all subjects mentioned in the state list, except 3: police, law and order, and land. And this Delhi Assembly can make a law on concurrent list as well. But despite that, look at this carefully. Delhi has a Legislative Assembly, but it is still a union territory. It is not a state. That means despite the fact that Delhi Legislative Assembly has the power to make laws on all items mentioned in the state list, on all items mentioned in the concurrent list. When we say all items mentioned in the state list, except police, law and order, and land, despite that, Parliament still has the power to make laws on any item for the union territory of Delhi. That means despite the fact that Delhi has a legislative assembly, it has a chief minister, but it is still a union territory. Despite the fact that Delhi Legislative Assembly can make a law on all items mentioned under the state list, but not on law and order, land, and the police. And despite the fact that Delhi Legislative Assembly can make laws on all items mentioned under the concurrent list, even then, Parliament has the power to make law for the union territory of Delhi, on all items mentioned in the union list, on all items mentioned in the state list, on all items mentioned in the concurrent list. That is why it is a union territory. If you look at Puducherry, for example, in the year 1963, Puducherry was given a legislative assembly. Now, Puducherry has a legislative assembly. Puducherry has a chief minister as well. That means Puducherry can make a law on all items mentioned under the state list, on all items mentioned under the concurrent list. But that does not mean Parliament has given up its power, because union territories are directly under the control of the center. Even for Delhi and Puducherry, Parliament has still retained its power to make laws. That means on all items mentioned in the state list, on all items mentioned in the concurrent list, Parliament of India can still make laws for the union territories of Delhi and the Puducherry. That means, long story short, when we look at union territories, they are directly under the control of the center. They are administered by the center, governed by the center. If you look at executive relations, President is the executive head of all these union territories, and President governs and administers these union territories through his officers, who are suitably named. Can be a Lieutenant Governor, can be an Administrator, can be a Chief Commissioner. Clear? But so far as legislative relations are concerned, for 6 other union territories, there is no confusion, because these 6 union territories right now, except Delhi and Puducherry, they don't have a legislative assembly. When they don't have a legislative assembly, who will make laws for these union territories? Parliament. Why? Because they are under the direct control of the center. The central legislature is the Parliament. Parliament will make laws for all these union territories. But what about Delhi and Puducherry? Puducherry, despite the fact that it's a union territory, it was given a legislative assembly in 1963. Despite the fact that Delhi is a union territory, it was given a legislative assembly in 1992. Despite that, Parliament has still retained its power. Parliament can still make a law on all matters related to Puducherry and Delhi. But Delhi Legislative Assembly has one disadvantage. It cannot make law on law and order, land, and police, because that is the exclusive domain of the center, because Delhi is a union territory. If you look at the judicial structure, Barring the exception of the Union Territory of Jammu and Kashmir and the Union Territory of Delhi or National Capital Territory, only these two Union Territories, they have their own high courts. But if you look at all other Union Territories, they do not have high courts of their own. They come under the jurisdiction of the neighboring high court, which means which high court has the jurisdiction over Ladakh? The High Court of Jammu and Kashmir. Which high court has the jurisdiction over Puducherry? The High Court of Madras. Which high court has the jurisdiction over Andaman and Nicobar Islands? The High Court of Calcutta. Which high court has the jurisdiction over Daman and Diu and the Dadra and Nagar Haveli? Which high court has the jurisdiction over the Union Territory of Lakshadweep, the Kerala High Court? That means these Union Territories, they have subordinate judiciary. They have the metropolitan courts. They have the district judicial authorities, but they do not have the high courts. They come under the jurisdiction of the neighboring high courts. Except two Union Territories, the Union Territory of Jammu and Kashmir and the Union Territory of Delhi, they have their own high courts as well. But whatever we have discussed till now can be important and relevant for your prelims examination. This Union Territory comes under the jurisdiction of which high court? Maybe match the following questions can be asked in your prelims. Or who is the executive head of Delhi? Who is the executive head of these Union Territories? This is the question that can be asked in your examination. For example, even in Delhi, although they have a lieutenant governor, but the chief minister and his council of ministers, they are appointed by the president, because president is the executive head of these Union Territories. Delhi, Puducherry, despite the fact that they have a legislative assembly, that does not mean Parliament has given up its power. Parliament can still make laws on all items mentioned in the Union list, state list, and concurrent list, even for Puducherry and Delhi. But Delhi Legislative Assembly has a disadvantage. It cannot make laws on law and order, land, and the police. Now, what we are going to discuss now, we are going to discuss something very important. Are Union Territories the outcasts of democracy in India? Let's have an elaborate discussion on this matter. Let me take you back to our discussion when we discussed part 1 of the Constitution of India. Then I told you that on 26 January 1950, we had Part A, Part B, Part C, and Part D territories. Part A, which were governed previously by the Governor General. Part B, which were princely states. Part C and Part D, they were controlled by chief commissioners. And there were 11 such territories in India, which were previously controlled by the chief commissioners. Now, the States Reorganization Commission, which was set up in 1953, it was given a task that you decide how should we reorganize this country. States Reorganization Commission came up with its report and said that out of these 11, 3 should be made as union territories. Why? For what purpose? Because of administrative reasons, because of security reasons, and because of other compelling reasons. What am I trying to say? Why do we have union territories in India in the first place? We are going to have a real discussion on this topic. Part C, Part D, there were 11 territories. States Reorganization Commission was asked, how should we reorganize this country into states or union territories? States Reorganization Commission submitted its report in the year 1955 and it recommended that out of these 11 territories, 3 should be made as union territories. Why? What was the logic given by the States Reorganization Commission? The logic was for administrative reasons, for security reasons, and for other compelling reasons, we should have 3 union territories. If you look at this phrase, other compelling reasons, this phrase is very vague. It does not tell us what are these compelling reasons on the basis of which we should have union territories in India. But the logic was clear. The logic said for administrative reasons, Delhi should be a union territory. Why? Because Delhi is the capital of India. If you look at the capitals of almost all the countries of the world, even if they are federal, their capital territories, they are directly under the control of the center. For that reason, Delhi should be made as a union territory. For security reasons, we should have Manipur as a union territory. Why? Because there is law and order problem, there is insurgency in Manipur, so we should have Manipur as a union territory. For other compelling reasons, we should have Andaman and Nicobar Islands as a union territory. But this report was partly accepted by the central government. Instead of 3, because the States Reorganization Commission recommended 3 union territories, in the year 1956, when States Reorganization Act was passed by the Parliament, we had 14 states and 6 union territories. That means although the recommended number was 3, States Reorganization Commission recommended 3 union territories, the Parliament instead created 6 union territories. Himachal Pradesh was the 4th one, Lakshadweep was the 5th one, and Tripura was the other one. So 6 union territories were created in the year 1956. Later on, many other union territories were created. For example, Goa was a union territory. Puducherry, when it was acquired, the French settlement of Puducherry, it was made a union territory. But over a period of time, some of these union territories were given statehood as well. Tripura, for example, Manipur, for example, Himachal Pradesh, for example, they were given the statehood. But what was the real logic of creating these union territories? If you look at the logic given was these territories, they are financially dependent upon the center, and they have a low population base, which basically means union territories are directly under the control of the center. If there are territories in India which have a low resource base, they cannot sustain themselves. They will be always dependent upon the center for funds. Ultimately, why we should have a legislature for that area? Why should we have a chief minister for that area? Because they are almost always dependent upon the center. So if there are territories which are financially not viable, which are almost always dependent upon the center for funds, which have low resource base, we should convert them into union territories. Let them be under the direct control of the center, because they are in any case dependent upon the center. Second logic was low population base. If the population of some territories is so small that if we give them democracy, it will become costly. It will become costly to have a legislative assembly for a smaller population base, a high court for a small population base, a secretariat for a small population base. Democracy would become very costly in areas which have a low population base. That is why there are 2 broad reasons why we should have union territories. That is why there were 2 reasons given in 1956 when we had 6 union territories. There are territories which are almost always dependent financially on the center. So why should we create states for these areas? We should convert them into union territories. And there is low population base, small population in these territories. We should convert them into union territories, because otherwise democracy would become very costly in these union territories. But both these reasons may have resonated in 1950s, but they do not resonate now. Why? Let's say, for example, Delhi. Delhi is not just the capital of India, it is also considered to be the crime capital of India, a rape capital of India. Its population is more than the population of 100 countries of the world. The population is very huge in Delhi. So why is it a union territory despite the fact that its population is very large? Despite the fact that we looked at low population base. Do you know what happened? When Mizoram was converted from a union territory to a state, its population was 6 lakhs. When Arunachal Pradesh was elevated from a union territory to a state, its population was 8 lakhs. When Sikkim in 1975, when it was admitted into Union of India as a state, its population was 2.5 lakhs. That means on one hand, in 1950s, you are telling us that because there are territories with very small population, that is why if we give them democracy, democracy would become costly. That is why let's have these small population territories as union territories. That means despite the fact that the population of Mizoram was 6 lakhs and you gave it a statehood, population of Arunachal was 8 lakhs, you gave it a statehood, population of Sikkim was 2.5 lakhs and you admitted Sikkim as a state, then what stops you from giving statehood to Delhi, where the population is more than 140 countries of the world? Second argument was that these territories are financially dependent. They are not financially independent. That means they are dependent upon the center for grants, dependent upon center for funds, dependent upon center for money. If that is the reason, then the entire Northeast and all the 7 sisters plus Sikkim, it should be converted into a union territory. Because all these northeastern states, also Sikkim, they are financially dependent upon the center. That means by that logic, they should also continue as union territories. That means these 2 reasons which were put forth in 1950s, that there are some territories which have low resource base, they are financially dependent, they have small population base, and if we give them democracy, it's going to become very costly. And for these 2 reasons, we have union territories. These reasons may have resonated in 1950s, but they do not resonate now. What is the solution that we can put forward? The solution is something we can imitate. What happened in Goa? Goa was a union territory. And then there was a referendum, or what we call Goa opinion poll in the year 1967. The people in Goa were asked, should you want to continue as a union territory, or do you want to merge with Maharashtra, or do you want to be given a statehood? Overwhelmingly, people in Goa, they wanted a statehood, they were given a statehood. That opinion poll we can imitate in all the other union territories today. Puducherry, since 1977. No assembly session is over in Puducherry unless until they pass a resolution that we need a full statehood. Since 1977, Puducherry is asking for statehood. Why can't we replicate this opinion poll model in Puducherry, in Lakshadweep, in other union territories? Why should we have union territories in India in the first place? Now you will ask me why. This is the answer. Preamble of the Constitution of India, it talks about objectives of the Constitution. And one of the objectives of the Constitution is justice. And one example of justice is political justice. Not just political justice, equality of status and opportunity to every citizen. That's also the goal mentioned under the preamble of the Constitution. Why is it that people in Karnataka, they get elected representatives and hold these representatives accountable? Either vote them in back after 5 years or vote them out after 5 years. Because these elected representatives, they're accountable to the people of Karnataka. But people in Daman and Diu, Dadra and Nagar Haveli, Lakshadweep, Chandigarh, Andaman and Nicobar Islands, they can't elect their representatives. They can't hold them accountable. Unelected Lieutenant Governor is governing them. Unelected Lieutenant Governor is making rules for them. Why should we make them second-rate citizens of this country, wherein the preamble promises them equality of opportunity and the status? Isn't Article 14 getting violated? Which talks about equality before law. If Constitution under Article 14 talks about equality, are we not treating different people in India differently? In the sense that people in Karnataka, Tamil Nadu, West Bengal, 28 states in India, they can hold their elected representatives accountable, but citizens of union territories, they cannot. And this is the one more important thing, and this is the paragraph that you can replicate your answers. The right to a democratically elected government at all levels is the foremost expression of this promise, which was made by the preamble to the people of this country. Until this right is granted to the people of all present union territories, no lesser citizens of India than others, definitely they are no lesser citizens than citizens of other states, the project of making India the world's largest democracy and convert this world's largest democracy into the world's greatest democracy. This promise, this project will remain unfinished unless and until we give the citizens of these union territories the say. Let's give them options, similar to what we gave to the people in Goa. Should you want to continue as a union territory, or do you want to merge with a neighboring state, or do you want a statehood? Let this option be provided to the citizens of all union territories. So 3 options should be provided. Either merge with an adjoining state. If this adjoining state, or if there are many adjoining states, choose which one is linguistically closer to you, which one is economically closer to you, and if you want, merge with that state. Second option, full statehood should be given to you. But obviously, if there is a union territory which is a very small population, this union territory can continue as the union territory. But if there is a union territory which is a large population base, give that union territory an option of getting a statehood. Or there is a third option, continue as union territory for a specified period before it should be merged with a neighboring state. These are the 3 options that should be given to the people of all these union territories. Either you want to merge with a neighboring state and adjoining state, or you should be given a full statehood, or if there's a conflict. Let's say, for example, Puducherry, to spread across different areas where it may not be possible for Puducherry to merge with the adjoining state Tamil Nadu. For that reason, you should continue as a union territory for some time till we resolve the conflicts, and then you should be merged with a neighboring state. These 3 options should be provided to the citizens of all union territories. Now let's look at the curious case of Delhi, or the National Capital Territory. Delhi till 1956, as I told you, was a state. Then it was converted into a union territory. Till about 1991, it continued as a union territory. Then in 1991, 69th Constitutional Amendment Act was done. Article 239A was added. This made special provisions for National Capital Territory of Delhi. Then NCT rules were issued in the year 1993, which basically means that there will be a legislative assembly in Delhi, but legislative assembly of Delhi will not have the power to make laws on land, law and order, and police. For all other subjects mentioned under the state list and the concurrent list, this legislative assembly of Delhi will have the power to make laws. Delhi will have a chief minister and his council of ministers. And what is the role? Role is to aid and advise the lieutenant governor. Then what happened? Sheila Dixit was the chief minister. There was not much problem because Sheila Dixit was the chief minister. There was a UPA government for a long time. There was no much trouble because the party ruling Delhi and the party ruling at the center, they were the same. Then came 2013. A new political party, Aam Aadmi Party, was in a position to win 28 seats out of 70 legislative assembly seats. Formed up an alliance with the Congress and were in a position to form the government. After 49 days, the chief minister of Delhi, Arvind Kejriwal, resigned because he wanted to contest Lok Sabha elections against the prime ministerial candidate of the BJP, Mr. Modi, in Varanasi. And ultimately, the government in Delhi collapsed and Delhi was placed under the president's rule. Clear? Then in 2015, the elections were held again. And in these elections, Aam Aadmi Party threw a surprise. Out of 70, 67 seats were backed by Aam Aadmi Party. Arvind Kejriwal became the chief minister for the second time. And soon he realized the peculiarity of the National Capital Territory, Delhi. One by one, legislative assembly is passing bills. The lieutenant governor is not signing these bills. Close to 14 bills were passed. Lieutenant governor is not signing any of these bills. Ultimately, what happened? The Delhi government is appointing doctors to mohalla clinics. The Delhi government is transferring the civil servants. All these decisions are vetoed by Lieutenant Governor. The then Lieutenant Governor Najib Jung, he says that I'm going to reserve all these decisions for the consideration of the president. That means since president is the executive head of a union territory, Delhi chief minister and his council of ministers, they are taking decisions. They're asking me to sign on these decisions. I will reserve them for the consideration of the president. That means basically what happens? There is a tussle. There is a conflict. Now we have to analyze and decide who is the real authority. Is the advice of chief minister and the council of ministers binding on the lieutenant governor, or is the real authority in Delhi the lieutenant governor and the president and not the elected chief minister? That went to the court. Delhi High Court, the year was 2016, and it was a big blow to Arvind Kejriwal and his government. In one single go, 18 million votes were rendered useless. Because when 18 million votes were polled in the 2015 legislative assembly elections in Delhi, people overwhelmingly voted for Aam Aadmi Party government. 67 seats out of 70, the people in Delhi woke to a peculiar situation. And they realized that the individual whom we have elected, he has no role, he has no power, he has no authority. The real authority is with an unelected lieutenant governor who is only accountable to the president of India. And in 2016, the Delhi High Court said the real authority in Delhi is the lieutenant governor. Chief minister and his council of ministers, they are only advisors of the lieutenant governor. Lieutenant governor can do whatever he wants to do because Delhi is a union territory. The argument that is presented by Arvind Kejriwal and his government, that we are the real authority and our advice is binding on the lieutenant governor, Delhi High Court said this argument is without any substance, and we are rejecting this argument. The real authority is lieutenant governor who is accountable to the president because NCT of Delhi is a union territory. But then the matter went to the Supreme Court. July 2018, the Supreme Court, a constitution bench of the Supreme Court, a 5-judge bench of the Supreme Court ruled by a majority that lieutenant governor of Delhi is bound by the aid and advice of the chief minister and his council of ministers, because that is what democracy means. Justice Chandrachud said, in democracy, elected representatives should have the power because these elected representatives, they are accountable to the legislature. So far as Delhi is concerned, we need to find a mixed balance, because despite the fact that Delhi is a union territory, but Delhi also has its own aspirations, and for those aspirations, they have elected their representatives to the Legislative Assembly. So we have to find a mixed balance. On all other matters, the advice of the Chief Minister and his Council of Ministers is binding on the Lieutenant Governor. But when it comes to law and order, land and police, Lieutenant Governor is not bound by the advice of the Chief Minister and his Council of Ministers. The Supreme Court said constitutional morality tells us that there should be rule by the people, and if people have elected their representatives, these representatives should be held accountable by the people as well. And for that reason, the real power is with the Chief Minister and his Council of Ministers. Whatever advice is given by the Chief Minister and his Council of Ministers to the Lieutenant Governor, the Lieutenant Governor is bound by that advice. And it is only in matters related to law and order, land and police that Lieutenant Governor will go by whatever President has to say on this matter. Because these matters are not within the control of the Legislative Assembly. These matters are with the Parliament of India. But there was confusion on one thing else. Article 239AA, clause 4. It says that Lieutenant Governor can refer any matter to the President, asking for the views of the President on this matter. Which basically means Chief Minister Kejriwal is recommending Lieutenant Governor that we have to recruit 20 doctors to Mohalla clinics, for example. When this matter reaches the Lieutenant Governor, he says, no, I have to refer this matter to the President. Basically, you're dealing decision on this matter, and President sits on this matter for as long as possible. Governance is getting affected in Delhi. This matter went to the court. The court had to now decide what will happen to this Article 239AA, clause 4, wherein Lieutenant Governor has the authority, has the power to refer any matter to the President. Chief Justice of India, Justice Deepak Misra, who was the Chief Justice of India then, he said, this expression, any matter, does not mean every matter. It does not mean that 14 bills that have been passed by the Legislative Assembly of Delhi, and they have been sent to you for your signature, and you are referring every matter to the President, asking the views of the President on this matter, and then you will decide whether you have to sign or not. Any matter does not mean every matter. Any matter would mean when there is a substantial matter which involves some element of constitutionality. That matter should be referred to the President for his views, which basically means matters related to land, law and order, police should be referred to the President. You can't say, I have the power, I as Lieutenant Governor, I have the power and I can refer any matter to the President for his views, thereby the governance will be hit in Delhi. That is something you don't have the power. Any matter does not mean every matter, and that is how the tussle between the Lieutenant Governor and the elected government in Delhi, this tussle was resolved. And that is the status of Delhi right now. And the similar problem we are facing in Puducherry. In Puducherry, Kiran Bedi is the Lieutenant Governor, Mr. Narayan Swamy is the Chief Minister. Narayan Swamy belongs to the Congress party. Ms. Kiran Bedi, she contested on a BJP ticket, then she fought election against Arvind Kejriwal and subsequently lost the elections. When we look at Puducherry, I told you since 1977, no session of Legislative Assembly of Puducherry has been dissolved unless and until they pass a resolution that we require and we need a full statehood. But in Puducherry, what is happening? The Chief Minister is rendered useless. Lieutenant Governor is creating WhatsApp groups, and in WhatsApp groups, she is directing the officers what to do, what not to do. You are basically making an elected Chief Minister irrelevant. Even if it's a union territory, should an elected Chief Minister be rendered useless? Then what is the purpose of having a Legislative Assembly and the Chief Minister in the first place? Matter went to the court. Madras High Court said no. Lieutenant Governor of Puducherry cannot do this. He cannot direct officers like this, create these WhatsApp groups and direct officers. This power is with the Chief Minister and his Council of Ministers. But what the Lieutenant Governor of Puducherry did, she knocked the doors of the Supreme Court. So there is a tussle going on in Puducherry as well. The tussle in Delhi was somehow resolved, but there is a tussle in Puducherry as well. So how can we resolve this problem? For that, we need to reimagine the concept of union territories in India. For that, the solution is simple. Union territory, let the people of that union territory be given an option. Three options. Full statehood, merger with an adjoining state, or continue as a union territory till the situation stabilizes. After that, you should be merged with a neighboring state. That's how you should look at this chapter, union territories, and this question: are union territories outcasts of democracy in India? That is all that you need to know regarding this chapter, union territories.
Hello everyone and welcome back to Polity Related Current Affairs, Puducherry Part. Now, why is this topic in news? V. Narayan Swamy, who was a former Chief Minister, the then Chief Minister in January 2021. Why? Because in April 2021, elections took place in Puducherry, and now we have a coalition government of BJP and All India NR Congress. So in January, the Congress party was a ruling party. V. Narayan Swamy was the Chief Minister, and the Chief Minister, along with other members of the cabinet and the members of the ruling party, staged a 4 days dharna and agitation against the LG. The LG in question being Mrs. Kiran Bedi, seeking her recall. Now, interestingly, right from the time since Kiran Bedi has been appointed as an LG in Puducherry, there have been constant conflicts between the LG and the Chief Minister or the government of Puducherry. I'm sure it reminds you of the exact same situation in Delhi. As of now, in fact, what happened was the very next month, Kiran Bedi was removed and the Governor of Telangana, Tamilisai Soundararajan, was given the additional charge of Puducherry as the LG of Puducherry. So matter was resolved, but that also brings in front of us a larger question on the tussle between the LG and the Chief Minister or the government. Now, what have been the various reasons for conflict? First things first, government has accused the Lieutenant Governor of interfering in the daily affairs of the administration. So much so that in 2017, what happened was 3 members were inducted in the Assembly of Puducherry. Now, we should be aware that the Legislative Assembly of Puducherry consists of 30 MLAs who are elected plus 3 people who are nominated. Now, these 3 people who were nominated were all BJP members. So the ruling party made allegations against Kiran Bedi saying that she is an agent of BJP. Why? Because she was not appointing people of eminence, she was simply nominating people who belong to BJP. Anyway, in 2018, Kiran Bedi also tried to interfere in the functioning, in the implementation of the National Food Security Act. If you remember, this was a law passed in 2014, which assures over 80 crore citizens of this country 25 kgs per month of ration. That is for a family of 5. Rice at 3 rupees per kg, wheat at 2 rupees per kg, and coarse cereals at 1 rupee per kg. Now, Kiran Bedi tried to pass an order, and she said that those villages and only those villages will be able to get the benefit of NFSA, the National Food Security Act, which had cleared the target of being an ODF, open defecation free village, garbage free village. And the government of Puducherry was very right in pointing out that there is no relationship between the food entitlement and the ODF target. Your rights are not subjugated to some scheme, some policy of the government. This is basically a right which flows also from Article 21, right to food. So it cannot be made subject to some provisions. Then last year, if you remember, on the 31st of December 2020, Kiran Bedi issued an order saying that in this pandemic, amidst the entire pandemic going on, please do not celebrate New Year. Do it in your house. Again, the government had to step in and it said that don't worry, you are free to celebrate New Year as per your wishes. So there have been constant tussles between the CM, the government, and the LG. Right? The government has cited the functioning of LG as autocratic, and they feel that the LG has adopted an obstructionist attitude, creating impediments in that developmental progress. Now, the larger issue here is with respect to the formation of Pondicherry and the provisions with respect to Pondicherry. Let's come to that. Now, coming to Puducherry as a union territory, India incorporated incorporated Puducherry along with the territories of Karaikal, Mahe and Yanam. Now, let's be clear. The UT of Puducherry consists of 4 different areas. This area, which is in Kerala, is Mahe. This area, which is in Andhra Pradesh, is Yanam. The top one is Puducherry, the lower one is Karaikal. Both of them in Tamil Nadu. This is in Andhra Pradesh. These 4 areas together form the UT of Puducherry, which were under the French occupation and became a part of India through the 14th Constitutional Amendment Act of the year 1962. Now, let's also understand the provisions of Legislative Assembly of Puducherry. Article 239A of the Constitution provides for legislatures or council of ministers or both for certain UTs which can be created by a parliamentary law. Meaning what? UTs can have a council of ministers, can have a legislative assembly. That's surprising. You can have a council of ministers. How can you have a council of ministers without an assembly? That's a very vague, very absurd framing of the sentence. But still, that's what's mentioned. And all this can be done by the parliament by law. Plus, this legislative assembly can have elected members or can have nominated members or can have party elected, party nominated members. So all these are mentioned under Article 239 capital A. Apart from this, there is also a law called the Government of UT Act 1963. It provides for legislative assemblies and council of ministers for certain UTs along with the related provisions. So this and this, these two are the provisions in place through which we have a legislative assembly for Puducherry. Now, apart from this, there are also rules of business. Rules of business of the government of Puducherry of the year 1963, which were passed in the month of June. So we have a constitutional provision, we have a law in place, and we have rules in place. These together provide for a setup, an administrative setup, which takes care of the effective functioning of the policies and programs in Puducherry. Now, let's also talk about the government of Puducherry. The government of Puducherry consists of the LG and the council of ministers, headed by the chief minister. And mind you, the chief minister is appointed by the president and not by the LG, just like in Delhi. You know, the CMs of the states are appointed by the governors, but when it comes to Delhi, when it comes to Puducherry, the chief minister is appointed by the president. That's the difference. Secondly, the LG functions under the aid and advice of council of ministers, which is not binding. At least it is not mentioned explicitly that it is binding. Finally, legislative assembly can make laws with respect to any matters in the state list or the concurrent list. But wait, even the parliament has the power to make laws on any matter in the state list as well. Normally, the parliament is not allowed to make laws on state list subjects under normal circumstances. There are exceptions, like if you have a national emergency in place, if there is president's rule in the state, if the Rajya Sabha allows under Article 249, if you have to give effect to any international treaty, if two or more states agree. These are exceptional circumstances. But for Puducherry, the parliament is allowed to make laws on state list subjects as well. And if there is any conflict, we know that the parliamentary law would prevail. That's one special circumstance. Now, let's understand the powers of the LG. If there is any difference of opinion between the LG and the council of ministers, the LG is bound to refer the matter to the president, and then whatever decision the president conveys to the LG will have to act as per the discretion of the decision of the president. But suppose the council of ministers asks the LG to sign on some particular proposal. LG says, wait, I have a different opinion. Let me reserve the matter for the president. Now the president is not that free that he'll immediately jump on and start looking at the matter. It may take some time, 10, 15, 20 days, 1 or 2 months. In the meantime, if the LG feels that it is very, very important, the matter is very important, the LG can take an independent decision on that matter till the time the president decides on the matter. Now this is very weird because there is no limit. What shall be the nature of difference of opinion is best left for LG to decide. That's a hell lot of discretionary power. Then prior sanction of the LG is required for certain legislative proposals. For example, if you want to constitute and organize the court of a judicial commissioner, then the prior permission of LG is required. That's mentioned under section 22 of the Act. There's more. It is obligatory on the part of the UT government to seek the recommendation of the LG before moving a bill or an amendment to provide for imposition, abolition, remission, alteration, regulation of tax, or any kind of security that has to be given to the consolidated fund of the UT, or any matter which relates to appropriation. Taking out of money from the consolidated fund requires the prior sanction of the LG. This is also mentioned in section 23 of the Act. There is more. The LG can exercise powers regulating the conditions of service of persons serving under the UT in consultation with the chief minister. Meaning, what? Who should be appointed to which post? Transfer of officers. All these things can be regulated by the LG. You know, considering section 23, where the prior permission of LG is required. Kiran Bedi went on and made a statement remark that this budgetary exercise also involves taking out money from the consolidated fund. So she would also have a say in the budget of the UT. That is going a bit too far, right? But again, the crux of this matter is, if the LG is hell bent on making the life of the government difficult in the UT of Puducherry, the Puducherry government can do nothing about it because the provisions heavily favor the concerned LG. Whether it is these sections or the rule mentioned under the government of Puducherry rules, all these favor the LG. The rules and the powers are treated heavily in the favor of LG. Also for the fact that UT is basically a territory which is under the direct control of the union. So these are some challenges, if you may say so. But observe an interesting point. Be it Delhi or Puducherry, we may feel that these are genuine loopholes, lacunas. But let's take example of Delhi. When did this loophole actually was clearly visible? Only when there was a different party at the center and the states, or at the UT level, meaning BJP at the center, Aam Aadmi Party at the UT level, and then BJP appointed Rajiv Jung, who was true to his name and literally had a jung with the Aam Aadmi Party. This was nowhere a problem when there was a Congress government at the center and a Congress government in the UT level. And trust me, this will not be a problem if there's a BJP government at center and a BJP government in Delhi. Just like Puducherry, you don't see any problem coming up right now. Why? Because central government is BJP, Puducherry government is also BJP. They are in coalition partners, so no problems there. So largely, it is more a political problem than actually a constitutional one. And this is something which is visible even in the states. In all those states where the ruling party is different from that of the center, you find the governors play a very proactive role. So much so that they sometimes also tend to interfere in the effective functioning of the government, a government which has won the mandate of the people at the state level. So, as I said, it's more of a political problem than basically a constitutional or a legal problem. Now, coming to a couple of issues, as I have already pointed out, Article 239A enables the parliament to create legislatures with elected or party-elected party nominated members. And this is very absurd. Why would you have a legislature with nominated members? Makes no sense. What about the aspect of accountability? People who are elected. The elected members of the legislature have accountability towards the people of the state, of the area. The people who are nominated, you can't hold them accountable. You can't hold them responsible. That's it. Secondly, there can be a council of ministers without a legislature. This itself is a very strange, a weird phrasing of words. What is the meaning of having a council of ministers without a legislature? It is as good as appointing some IAS officers. Appoint them, let them run the particular UT. And then there's also an issue. When Kiran Bedi nominated 3 members who were BJP workers, members of the party BJP, in the Legislative Assembly, it was challenging the Supreme Court. This happened in 2017. Now what happened? The petitioners filed in the Supreme Court that Kiran Bedi had not consulted the chief minister while making these nominations. The matter went to the Supreme Court. And in 2019, K. Lakshmi Narayan case, Supreme Court said that the LG need not take the permission, the consent, or even the consultation of the CM is not required. You are free to nominate anyone who should otherwise be duly qualified, age factors and all. You are free to nominate. There is no need to take any kind of consent. There is no need for any consultation. No confidence is required of the CM or anybody else. So this matter is already settled, right? So that's all as far as the Puducherry CM is concerned. And in general, what exactly is the functioning of the UT of Puducherry with certain challenges. Let's look at a sample question. Consider the following statements. Parliament cannot make legislation of matters in state list for the UT of Puducherry. Number 2, UT of Puducherry does not have representation in Rajya Sabha. Let's come to the first statement. Parliament cannot make legislation on matters in the state list. It's incorrect. We know for a fact that Parliament can make laws on state list subjects in the UT of Puducherry. So one is wrong. UT of Puducherry does not have a representation in Rajya Sabha is also wrong. There is a representation. One person from Puducherry goes to Rajya Sabha as well. So 2 is also wrong. Right answer is D, neither 1 nor 2. That's all for this video. Thank you.